Good morning. Today is September the 29th, 2010. And on behalf of the Nashville Bar Association as primary sponsor and the Tennessee Supreme Court Historical Society, video interviews are being conducted with some of our greatest lawyers and judges in the state of Tennessee. I'm Frank Drewota, and today it's my pleasure to interview Ben Cantrell. I have known Judge Cantrell for many, many years. I had the privilege of serving with him on the Davidson County Chancery Court bench in the early 70s. Ben and I have been good friends and colleagues since that time, over 38 years. Ben Cantrell is the hardest working, brightest, smartest judge that I have had the pleasure of dealing with. But I think one of the things that people remember him most is he's a great listener. And today we get to listen to him. But he has the greatest judicial demeanor of any judge in the state of Tennessee. He is highly respected by both the bench and bar of our state. And now it's my opportunity and pleasure to introduce you to Ben Cantrell. Ben, would you state your full name, please?
I'm Ben Howard Cantrell.
And Ben, would you tell us where you were born?
I was actually born in the hospital in Murray, Kentucky, but my parents lived a little bit southwest of Murray in the edge of Weakley County, Tennessee, in a little town called Palmersville.
How large is Palmersville?
Well, at one time it had about 150 residents. I doubt if it has that many now.
Did your parents continue to live there?
Yes. My father built the house where I was born the summer before I was born. I lived there all my life, and it's still in the family.
I think your mother and father have passed away.
They have.
Would you tell us their full names and what they did?
My dad was William Cecil Cantrell. My mother was Hilda Alderdice Cantrell. Dad was a lumberman. He ran a sawmill, a timber business, and my mother was a school teacher.
And you lived in that area of Weakley County. Is Dresden the county seat?
Dresden is the county seat, 10 miles away from Palmersville.
So you've had some important Tennesseans in your area.
Absolutely, yes.
Would you want to name a few?
Well, I happened to be born in the same little hamlet that Governor Ned McWhorter was born in. And everybody knows Ned, knows of him. And Dresden, for a small county seat, was a town that had a lot of good lawyers in it. I won't try to name them all, but it was always impressive to me how many good lawyers lived and practiced in Dresden.
I understand you're the youngest of 4 siblings.
5, actually.
5.
4 boys and 1 girl.
All right. Could you tell us about your brothers and sisters?
My sister, Billie Jean, was the oldest. And then there were 4 boys, Bob, next to her, Glenn, Jim, and myself.
How did y'all get along?
Oh, we got along fine. I was the youngest, and they all kind of looked after me, I guess. Even, when I was grown and married and had a good job, my brother Bob always inquired about how I was doing, and he was always interested in helping out if he could or if he had to. We were all very close family.
Do you remember your grandparents?
On one side, my mother's parents were living, and my grandfather Alderdice died in November of 1945. My grandmother Alderdice lived on until about 1963. My dad's parents both died when he was about 14. His mother died in childbirth. his father died a little later on that year. So he was kind of put out on his own when he was 14 years old.
When and where did you meet Rose?
Met Rose when I was a senior in law school. She was a senior in college, and that's where we met.
When did you get married?
We got married in December of 1966. The December after I passed the bar exam and had started practicing law here in Nashville.
Tell us a little bit about Rose. I understand we all know that Rose has had a distinguished career herself as a lawyer, but has recently retired, and I understand that Sandy and Tom White had retirement party for Rose on their farm, and that you gave some interesting background. Do you remember any of that background of Rose that you gave at that party?
Well, I tried to invite guests to the party who represented the various phases of Rose's life and career. She's from a family of 12 children, grew up in Chattanooga. There were 5 of her siblings there, her oldest brother Pat, and then 4 of her sisters. And then, her law school days, her classmates from law school, some of them were there. And then she worked at Metro Legal Department, and we had several of those there. And then her law firm was Parker, Lawrence, Cantrell, and Dean, and they were all there, representing that part of her life. Rose has had an interesting career. She was actually the first woman trial judge in Davidson County. When Judge Steve North decided to run for DA back in 1982, he resigned from the Fifth Circuit Court, and Governor Alexander appointed Rose to fill out that term. She got beat in the August election, but she was actually the first woman judge in Davidson County.
We'll get back in a little bit to that election and some of your elections, because I think those are interesting things for Tennessee history. But I have met your 2 beautiful daughters at an early age, back in the early 70s, when on Saturdays or Sunday mornings we were working at the courthouse. You would be babysitting to some degree, because Rose was studying for the Nashville School of Law, I assume, at that time. Could you tell us the ages and a little bit about your daughters?
Yes, our oldest daughter, Laura, is 44 now. Our youngest daughter, Julie, is 40. And in 1973-74, they were just young children, and that's when Rose started the law school. She started to the night law school in 71, and so she was busy studying during that period of time, and as you and I remember, we had a lot of work to do. And so it's amazing to me that there were 2 of us. There were 2 chancellors back then, and so we really did have our hands full. And we worked a lot on the weekends, and the girls would come with me and they loved to play in the courtroom and turn on the PA system and sing and draw on the easel and do stuff like that.
Yeah, it was always interesting on Monday mornings for the lawyers to come into that court and see the artwork that your daughters had left either on the easel or on the blackboard. At that time, we still use those.
Yeah, that's true. Sometimes they would draw on the sketch pad on the easel, and maybe they turned it back over and nobody knew it was there until some lawyer wanted to use it during the next trial, and they discovered some fancy artwork on the easel.
You had some talented daughters, and Laura is a musician, is she not?
She is.
And a singer?
She has a country music career. She lives in New York, She went to school at Columbia in New York and decided she liked the city and stayed there. But she has pursued a music career since that time and done very well with it.
I had the opportunity to perform her wedding ceremony at the state capitol, I remember, and I'd never seen a wedding performed there, and it's a beautiful location for a wedding. So how long have they been married? And tell us a little bit about their family, her husband.
She married a New York boy. He grew up in Poughkeepsie, went to NYU, and then they married in 1997. And they have a 4-year-old daughter, Isabella. So we have one grandchild.
And where did Laura and Julie go to grammar school, high school in Nashville?
Well, they both went to the university school for several years. I guess Laura went to the university school through the 8th grade. And then she went to Father Ryan and graduated from Father Ryan High School in 1985. Julie went from the university school to Harpeth Hall, and she graduated from Harpeth Hall in 1988.
Let's get into your educational background. Where did you go to elementary school?
I went to the Palmersville Elementary School. We had a school in Palmersville.
How many were in your class?
Well, in my graduating class in high school, there were 18 of us. There were 12 girls and 6 boys.
12 girls and 6 boys.
Right.
And you went to high school there also in Palmersville?
Right. All 12 years of school were in Palmersville.
And then where did you go to college?
For 2 years, I went to Bethel College down in McKenzie. And then I transferred to Vanderbilt, and I got an engineering degree in 1957.
What was your favorite sport or activity in your high school, college years?
I played basketball in high school, and I played over at Bethel for a couple of years. So basketball, I guess, was my favorite sport. We didn't have enough kids to field a football team, so we played basketball and baseball. I've always been a big baseball fan too.
What were your favorite courses in high school, college?
Well, we didn't have a lot of instruction in the sciences in high school. We had such a small school. I guess English literature would have been my favorite subject in high school. And I had planned when graduating from high school to get an engineering degree, and so I plunged into the math and science curriculum there.
So when you graduated from Vanderbilt with your Bachelor of Engineering, what type of job did you take?
I took a job with the Atlantic Refining Company, they called it. It was an old Pennsylvania oil company. They had a Southwest headquarters in Dallas, Texas. And so I went to work with them when I graduated from Vanderbilt.
And I believe you worked for them for about 6 years?
I did. The first year I was on a training program. They put their young engineers on a training program. And the Southwest Division in Dallas was concerned primarily with production, oil field work, drilling and production, and some refining. The company had a refinery at Port Arthur, Texas. So that was the type of work I was doing for them.
Who or what got you interested in the law?
You know, people ask me that a lot, and I have a hard time explaining that. But I was still single at the time, and I decided, and I had thought about maybe going to law school, And so I decided if I was ever going to do it, I'd better do it. So I enrolled in the University of Tennessee Law School.
And you were there for 3 years.
Right.
And it was there, as you said earlier, that you met Rose.
Right.
Okay. And then you passed the bar in what year?
1966.
And what was your first legal job?
I had taken a job when I graduated from law school with the Nashville firm of Gullett, Steele, and Sanford, it was called then. And so I came here, and I'd already started working with that firm before we got the results of the bar exam.
Was Jack Robinson and Gil Merritt in the firm at that time?
Jack was. Gil was not a member of the firm at that point. Charlie White was one of the more senior partners, and Jack. Jack may have been the youngest member of the firm when I started there.
And then from Gullett, Steele, and Sanford, you went to what, Clement and Smith?
Yes, I went to the law firm of Clement and Smith. Governor Frank Clement had just finished his last term as governor, and he and Grant Smith were in a partnership, and so I went and practiced with them.
What type of practice did you have back then?
General civil practice. We didn't do a lot of criminal work, except back then you got appointed to cases, and so you had to do some of it. The firm did a lot of work in the music business. They had several clients that were involved in either performing or managing or running publishing companies. So a general civil practice, did a lot of domestic work. Whatever you could find, you did.
And so you were with Clement and Smith from 1968 until 1973, and obviously Governor Clement was Democrat back in those days, and kind of, I think they, as I recall, had 2-year terms, and he and Buford Ellington would kind of flip-flop. Was Grant Smith also a Democrat?
He was. They were both good, loyal Democrats. But I have to say, back then, it didn't seem like everything was as partisan as it is now. Governor Clement had always done very, very well in the Republican areas of the state. And the truth of the matter was that the Republicans never mounted much of a campaign for governor. Governor Clement had been popular in those areas, and so we got along fine.
From a historical standpoint, I think the first Republican governor was Winfield Dunn, and who was his opponent?
His first election, first run, was in 1970, and the Democratic nominee was John J. Hooker.
And so Governor Dunn served from 70 until about 74, I would
Right.
say. And so Governor Dunn was the one that appointed you to the Chancery Court bench?
That's correct.
And when was that?
In January of 1973.
And what were you, about 39 at the time?
Yes, that's right. 38, I guess.
38.
My birthday is in December, so I just passed my 38th birthday.
So even though you were relatively young, you were older than the other chancellor that was there in 73.
That's correct.
Tell us a little bit about the Chancery Court in the early 70s prior to getting the third chancellor.
Well, we had a lot of business, you and I. We didn't try divorce cases. We didn't try many workers' comp cases. The divorce jurisdiction had by agreement been passed to the Fourth Circuit Court when it was created sometime in the 50s, I guess. And Judge Benson Trimble became the first judge of the Fourth Circuit Court, and he heard all of the domestic cases for a long time. Workers' comp cases were just, I think, by tradition, tried in the circuit court, although we did try a few of them. We had a lot of cases involving state boards, agencies. I remember you had to try the case involving the election of a judge down in West Tennessee, really notorious case on and decided that the election wasn't really valid. It was a write-in election, and so we had a lot of that. We had a lot of cases involving rates paid by utilities, telephone company cases. We had a lot of cases involving the boards and commissions in Davidson County, the Board of Zoning Appeals. There was a lot of activity in the county back then, so we had a lot of that. We had a real general type of work, and we had a lot of it to do, as we have said.
Well, Chancery Court in those days and today is a very special court because it does hear constitutional questions and tax questions, and it's kind of a business law court. What type of cases did you like the most?
Well, I guess I enjoyed hearing the cases involving boards and commissions and state agencies. Most of them were heard on the record, and so we didn't have to take a lot of proof. Although I enjoyed hearing cases too, where we did have to sit and listen to the proof. We didn't have many jury trials back then. In all of the time I was in the Chancery Court, I think I only tried one or two jury cases. People just didn't demand a jury then as much as they do now, and we didn't have a jury box, if you remember. We had to set up some chairs for the jury to sit in the Chancery Court.
The only jury trial I ever tried in my 4 years down there, I remember, was Tom Shriver was trying to enjoin Deep Throat. And I had a packed courtroom of people wanting to view that particular movie. What were the hardest type of cases in Chancery Court? I remember I really did not enjoy the South Central Bell rate cases. Those seemed to be so complicated and required so much attention and effort.
Yeah, they were tough because they were always so politically charged. There were so many people that didn't want to pay a higher telephone bill. They didn't want to pay a quarter for a local call, and PSC was always careful not to raise the rate for a local call at a payphone from a dime to a quarter. They were hard, but they were also hard cases that just involved people and hardship on people, and having to make those decisions that was a hard part of the work. I remember a case, it was actually just a unlawful detainer case. An old lady had an employment business in the Sudicum building here downtown Nashville, and somebody had robbed her and beat her up on the premises, and she couldn't pay her rent. And they brought a detainer action to evict her from the premises. And that was hard because I really did feel sorry for her, but there wasn't a whole lot I could do for her. We had, a lot of those cases also.
One of the things in Chancery Court that I found, you had good lawyers, and good lawyers made it a lot easier for the judge in trying cases. Can you think of significant cases that you decided on the Chancery bench, cases that were perhaps most newsworthy?
Well, I guess one of the first big cases I was involved in involved the reappraisal of all the property in Davidson County. The legislature had just passed a law requiring the counties to reappraise all the property, and the county had hired somebody to do that, and the tax assessor, Mr. Clifford Allen, didn't like the way they were doing it, so he brought a lawsuit to enjoin the consideration of their values, and he wanted a temporary injunction, and time was short, and so we had to try that to the early hours of the morning for 2 or 3 days. That was hard, and it was also one of those cases that was fraught with political implications because it involved everybody's taxes. That it had to be done. We had to do it. And I had one of the first cases, I think, involving the Open Meetings Law, Open Meetings Act. And the school board had voted to fire a teacher, I think. And they'd heard the proof in open session, but then they closed the session to deliberate, and they voted to fire him, and somebody brought a lawsuit on his behalf saying that what they did was void because it was done in violation of the Open Meetings Act. And that was true, and it was interesting case because the school board back then was appointed, and Mayor Briley had done a good job in appointing some real leading citizens to the school board. And I remember Bill Harbison, the smartest lawyer, I guess, that ever practiced in the state of Tennessee, was on the board. Harlan Dodson Sr. was a member of the school board. And so I had to wind up saying to these good lawyers, y'all have violated the law by conducting your part of your meeting in violation of the Open Meetings Act.
What was a typical day like in Chancery Court prior to getting the third chancellor? I can recall you and I both struggled to try to get a third chancellor, but I don't think Bob Brandt came on until when?
I think Bob came in 1976.
Six.
Yeah. In Chancery Court, you have a lot of applications for temporary restraining orders. What we call the new rules of civil procedure had been enacted, went into effect, I think, about 1970. And so the way to obtain a temporary restraining order was laid out in the rules then. And then we had injunction hearings. Rules provided that you had a TRO could only last for 15 days, and then you had to have a hearing. And we had those hearings at 8:30 in the morning before we took up our regular docket. And then we took up whatever we had set for trial that day. And we tried them. And typically, I think you and I both would set maybe 3 cases a day, knowing that not all of them would be ready for trial. But we had enough cases set that we never had many gaps in our trial docket.
Did you write many opinions on the Chancery bench?
I did. More than I should have, probably. But I guess starting out, I wanted to be sure that I got it right. And so we did take a lot of cases under advisement, and we have to write opinions, and that's what we were doing on the weekends, was trying to catch up and get the opinions written that we had taken under advisement.
After 7 years on the Chancery bench, a person like yourself who wrote many opinions, was there a change though for you going to the Court of Appeals?
Well, there wasn't such a big change in writing opinions, but going from a trial court to an appellate court, where you have to work on a panel of three, was a change. When you're a trial judge, you're down there on your own, and you make the decision whether it was good or bad. On the appellate court, in the Court of Appeals, we had to work with that panel, and so then we had to confer and convince other members of the panel what you wanted to do was right, or let them convince you. And so it was a change in that respect. And actually it was change in another way, I guess, and that was that you had more time on the appellate court to reflect and to consider it and to write opinions, because you didn't have to open court every day and try whatever they had ready for you. So that was a change too, and an enjoyable change.
You served on the Court of Appeals for 23 years. Can you tell us who you served with, and maybe a one-sentence sketch of each one of those?
Yes, when I first went up to the Court of Appeals, Judge Henry Todd was the senior judge on the middle section. Judge Sam Lewis from Pulaski was on the court. And there were actually two vacancies. The court had been expanded from 3 judges, each section had been expanded from 3 judges to 4 in the late 70s, and I was appointed in 1980. And I was appointed in September. Lou Connor was appointed to the 4th seat later on that year.
And you served with them, and then was Lou the first to leave?
Lou served, I guess, until about 1984, and he left to go back to the private practice of law. And Bill Koch was appointed by Governor Alexander to take that seat.
And then there seemed to be later, as you became the presiding judge of the middle section, who was on the court with you at that time?
Well, when Judge Todd finally retired, then Patsy Cantrell was appointed to that seat, Judge Koch and I, and there was a 4th one. I'm forgetting now right now who it was.
Well, that court really, as you said, in Chancery, you didn't try that many domestic relations cases, but your Court of Appeals really was the court that pretty well developed the law in domestic relations, did you not?
That's true. We had a lot of domestic relations cases appealed to the Court of Appeals. It wasn't by any stretch of the imagination the majority of what we did, but just absolute numbers, I suspect that there were more domestic cases that we had to hear than any other single type.
Can you recall what significant or newsworthy cases you had during your 23 years on the Court of Appeals?
Well, it's hard to pick out. The most significant one celebrated case, I guess, we had was a case called Mayhew versus Wilder, where the plaintiff insisted that the legislature had violated the Constitution by having closed sessions. That was an interesting case. Basically, I think we decided that the legislature, as an independent branch of government, could interpret their own rules, and whatever they said they meant was up to them. But that was an interesting constitutional question. We had several cases involving sale of alcohol, and the Dram Shop Act, which was passed sometime in the 80s, imposing liability on people who sold alcohol and then who went out and hurt somebody in a car or did something else. Those were interesting cases. And as I say, we had a lot of domestic cases where we had to decide the custody of children and how the property was divided. And it was interesting to me because when I was in law school studying domestic relations, we spent a lot of time trying to decide what the grounds for divorce were. They were all statutory, of course, and people fought over the divorce back then, but as time has gone on, now they fight over the children occasionally, but mostly they fight over the money. And so that's been a real change in the domestic relations practice in the last 20 years.
Did you find the child custody cases to be some of the hardest you had to deal with?
They were hard. And asking 3 judges in Nashville to decide what's in the best interest of a child from Gainesboro or somewhere, that's a hard job. And they're not fun because it's always a very emotional thing for parents to be told what they can do about their children. So that's a hard job.
Do you remember your first published opinion?
Well, I'm afraid I do. I think it was, I don't remember the style of it, but it had to do with, it was a domestic relations case, and it had to do with the division of property, I think. And we decided it, and I decided that the fault of one of the parties had something to do with how the property should be divided. And Supreme Court denied certiorari, got published. Well, it turns out the fault didn't really have anything to do with it. It was division of property and not alimony. and forever after that, and the style of the case was Shackelford, I think. After that, when people cited Shackelford to me, I knew it wasn't really good precedent because I just simply missed it in that case.
Is the Court of Appeals a law development court?
It is, yes, to some extent. It does have to decide cases and decide cases where there is no precedent for what you're being asked to do, and so you do have to participate in the development of the law on the Court of Appeals.
Does any case stand out where the Court of Appeals really sought to change law that had already been developed?
Well, I can't think of any case right offhand. I know in the area of comparative fault, trial judges had tried to change the law. I think the Court of Appeals, though, always deferred to the Supreme Court, and we didn't do a lot of changing the law in that area. I do remember I'm sure it was one of the hardest decisions that we had to make. And Judge Connor had to write the opinion. It was about a guy who was an electrician, and he was up on a pole and stringing some new lines, and they'd got into a tree way down the line somewhere, and they got electrical feedback, and he got frozen onto the line. It didn't kill him, and they pulled him off of the pole, and he fell to the ground, was hurt severely. Well, it was in the days, though, of contributory negligence, and he didn't have his gloves on up there, and there wasn't much we could do except say he was contributory negligent, and that was a bar to his claim. And that was hard, and it's probably one of the cases that persuaded you on the Supreme Court to adopt the comparative fault later on.
Yes, the court through the 80s and up through 80 to 90 really never even took up that issue, because I guess the court there were at least 3 members that were probably opposed to it. I can recall reading in the terms of not dissents but concurring opinions where the Court of Appeals would say we would think some form of comparative fault should be adopted. But that didn't really occur until about 93. When your court would disagree, for example, on an issue of law between the East and the West, what would you do?
Well, we of course tried to accommodate what other sections of the court had decided. And in the early days, when I first went up to the court, we didn't have much of a procedure for resolving those conflicts, and so there were a lot of conflicting opinions between the East, West, and middle sections of the Court of Appeals. Later on, we adopted some rules that provided for an en banc hearing when that arose, but it resulted that there were a lot of conflicting opinions between the sections of the court.
An en banc hearing would require 12 judges, I assume, and I can't recall any of our courthouses that could seat 12. Did you ever have an en banc session?
We never did, in all the time that I was there. They had one earlier, and I don't know if you participated in that or not, but it didn't go well, as I heard judges describe the procedure, and I think everybody got afraid that it caused more trouble than it was worth, maybe. So we never did have an en banc hearing after that.
It's easier to work with a 3-judge court or a 5-judge court. I can't imagine a 12-judge court, how that would work.
Yeah, and that's, there are not a lot of dissenting opinions on the Court of Appeals because you are working with a 3-judge panel, and it's much easier. And in the middle section, we were all just on the same floor down the hall from each other, and if we need to talk about a case, we could just walk down to the other judge's office, and so we worked out most of the problems that we had. If you have 5 judges, then there's always more room for dissent. And if you have 9, as the U.S. Supreme Court does, then there's always going to be a lot more room. But occasionally, there were things that we couldn't resolve, so you did have dissenting opinions.
When you moved from the Davidson County Courthouse to the Supreme Court building, was there a major difference?
Yes, it was. And I remember Judge Allen Cornelius, who had made that same trip from Davidson County Courthouse up to the Supreme Court building. And I think he described it best because he had to go back down to the Davidson County Court to hear some post-trial motions after he had gone up to the Court of Criminal Appeals. And he described it as like going back to the front after you'd been on leave. It was everything around the Davidson County Courthouse was really hustle and bustle, and it was a lot quieter up on 7th Avenue.
Well, you didn't see as many lawyers on 7th Avenue as you saw at the Metro Courthouse, I'm sure.
That's true, and you know, that's one thing that a lot of judges don't like. They don't like what they see as the isolation on the appellate court. You don't get to see as many people, but I never found that to be a real drawback because we were downtown Nashville and we had lunch with the people and we, you know, weren't really isolated.
What were your favorite places to have lunch?
Well, I guess the most favorite place in downtown Nashville in those days was a place called Satsuma Tea Room, I think the full name, on 4th Avenue. Then it had been a restaurant in Nashville from the time of World War I and been in various places, but it was for the last 20 years or more, I guess, on 4th Avenue.
And as I recall, they had a men's table there for a period of time. It quickly changed, though, to men's and women's table, particularly when you got women on the appellate bench.
Yeah, that was a time when men's tables, I remember the men's balcony at the Zager's restaurant on 4th Avenue. They got integrated and really didn't cause much of an uproar. But the men's table stayed at Satsuma until it closed. But everybody was welcome. You know, maybe women didn't want to come in and sit down with a bunch of men who were just interested in telling their stories. But they kept the men's table until it closed.
Talking about stories, politics and judicial elections always bring out some interesting stories. You ran in 1974 against a man that I had run against in 1972. Could you tell us a little bit about that campaign?
Yeah, of course I'd been appointed by Governor Dunn, a Republican governor, and I was running as a Republican, which is scary in Davidson County.
Had a Republican ever been elected in Davidson County?
No, I don't think any Republican, well, to my knowledge, I don't think any Republican had ever been elected in a countywide election in Davidson County. And so it was a scary time. Fortunately, you know, a lot of political campaigns turn on the quality of your opponent, and so I was fortunate that my opponent was not a very popular lawyer. And so everybody in Davidson County, all the lawyers, and some who'd never voted Republican in their life, got out and worked hard for me, and I was able to get reelected.
I can remember '74 well because there was a Democratic primary, and I was a Democratic chancellor at that time, and the bar of Davidson County had all agreed that the Democrats would not run anybody against Ben Cantrell because he was such a great judge and was going to be running as a Republican. But then we found out it only took 25 signatures to qualify somebody, and Stan Sidicane got 25 signatures, and he became the Democratic nominee, did he not?
He did, yes.
And after he was the Democratic nominee, you were the Republican nominee. I remember at events, none of the Democrats would have their pictures taken with Stan Sidicane. But in 74, Judge Prieur of Gallatin retired, and there was a vacancy that occurred on the Court of Appeals. And I remember going into your office, I hope you remember this, I think in the spring of 74, and basically said, you ought to seek the Court of Appeals appointment because Winfield Dunn is the governor and you would have a good shot at it. And I wouldn't seek it if you did, but if you didn't, I would. And what was your response? Do you recall?
I do, yes, because that's a pretty big decision.
Major.
To have to make. But I told you, I think, basically this, that I had been there for just over a year, and you'd done a good job, and if you wanted it, you deserved it, and go ahead and apply for it. And I realized that I've got a very dangerous campaign to run if I stay here and run for re-election, but it just seemed like the right thing to do. And so that's the way we worked it out.
You made a real sacrifice in choosing not to seek the Court of Appeals, to stay and to have to run in a contested race. But I think the reason you did that is you did not want the bench in the bar of Davidson County to have someone like a Stan Sidicane be the chancellor. And there's no question you had labor behind you, which is usually behind Democrats. You had the Tennessean behind you. Obviously the banner was behind you. You had the bench and bar behind you. So we all thought you would win, but there was still always a risk when you run in something like that. And that was a real sacrifice on your part, because as I recall, Stan Sidicane later moved to Florida to practice law and was disbarred down there. He would have been a disaster for the Chancery bench.
Well, he got in some trouble here, and I don't really know the details, but Tom Shriver was the district attorney, and I think General Shriver made him an offer he couldn't refuse. He didn't get disbarred here, but I think one of the conditions for General Shriver not to pursue him for some criminal act, I don't remember what it was that he leave town, not practice law here, and that's the route he chose.
What was that 74 election like? Did you enjoy actually going out and meeting the people?
I did enjoy that, but I have to say that is really hard work because I knew I had to get out and really campaign because I wasn't well known countywide, and a judicial race is hard to run in because most of the people, even fairly well informed voters, don't realize why you're running for a judgeship in the first place, what you do. And here I was running for a chancellor's position, and I can remember people asking, what school are you connected with? Because they thought chancellors were college presidents or something. So it was really hard, and the times to meet large groups of voters are when the shift changes at factories, and that's early morning or middle of the night sometimes, and there must be 25 fire halls around Davidson County, and they have 3 shifts, and you try to meet all of them in every shift, and so it's a big job. Now, you mentioned though the support that I had, and I did have the support of both newspapers, and they did a marvelous job in helping me. And I, of course, being new to this political game, actually early on in the campaign hadn't asked either newspaper for their support. And I got a call one day in my office at the courthouse, and it was John Siegenthaler, who was I don't know if he was a publisher then of the Tennessean, but he said, "You haven't asked for our support, but if there's anything we can do to help, we'll be happy to do it." And so you don't forget stuff like that. It was a real boost to my campaign to have that kind of support. And got labor's endorsement. I don't know if they ever had done that before for a Republican. I remember talking to Cecil Branstetter. Cecil, of course, was a very strong Democrat, and he told me he'd never voted for a Republican in his life, but he wasn't going to hurt me. So that was a big boost too. And it was, looking back on it, it's fun. It's hard when you're doing it, but you have to do it.
Yeah, you even got some of the Yellow Dog Democrats voting for you. I think the first time they'd ever voted for a Republican.
That's true.
They said it was a good thing it wasn't a primary, because they sure couldn't vote in a Republican primary, but since this was the general election, they were okay with that. Fortunately, a vacancy did occur on the Court of Appeals, and that is a different type of process, is it not? What plan, the Tennessee plan, what did you go through in 1980?
Well, by 1980, the legislature had provided for the selection of appellate judges. It didn't apply to trial judges, but appellate judges were selected by a process where you applied to a group that had been appointed statewide called the Appellate Court Nominating Commission. And you applied to the commission, and they interviewed all of you, considered your credentials, and then made a recommendation to the governor. And they would send 3 names to the governor, and the governor could pick one of those 3 for that appointment, or the governor could ask for another panel of 3. So that was the process then.
So you would appear before this commission. I think I recall even going, and Jack Robinson, as I recall, spoke on your behalf.
Yeah, I'm trying to think. John Hollins was one of the persons who appeared on my behalf, and I forget who else, but you tried to get the people you thought were respected by the other members of the commission, and get them to go and say a few words in your behalf. I do remember also that Judge Robert Clement, Governor Clement's father, was a member of the commission, and that was he was a good friend, and he was a real help to me.
Do you recall the 3 names that went to the governor?
Yes, I was one, Lou Connor was one, and Joe Haynes. Joe is now U.S. District Judge, has been for many years. It doesn't seem possible that we're all as old as we are, but those were the 3 names that went up.
And those are 3 excellent names, and it shows that, to me anyways, that's a good type of a process and screening process, and sending 3 excellent names to the governor to choose from. So that was the merit selection, and then there's a merit retention that you, I assume, did in 82 and 90 and 98, so your name was on the statewide ballot. Tell us a little bit about that. You have, judicial evaluations that were...
Well, we didn't have, back then, initially, a judicial evaluation commission. It was created later. I don't remember exactly what year. But you did have to appear on the statewide ballot every 8 years. And, of course, I was filling out a part of a term. And so we appeared on the ballot. And most of us didn't try to get out and campaign. Some judges did, and they'd run a few ads, but it just seemed more prudent to sort of lay low and let the people who had practiced before you spread the word for you. And it was generally successful.
Yes, as I remember, that was for the Court of Appeals, because the Supreme Court did not get the merit selection and merit retention until about 93 or 94. And as I recall, in the first race, first person whose names appeared on the ballot, Penny White was defeated in a merit retention race over that was, in my way of thinking, kind of a sad situation, because it was a single issue. She had been involved in a death penalty case, and papers and others just went out after her. Give us your thoughts on, because these are issues that are coming before the legislature in the present day and in the future. Tell us your thoughts about merit selection, merit retention versus statewide judicial elections, because they're considering that for the Court of Appeals also.
Yeah, and I shudder to think about having to run a statewide race, especially when you're on a court that serves basically just the people of Middle Tennessee. I don't know how the Court of Appeals judges did that in the old days. And you know, it takes a lot of money to run a campaign. You're going to have people who want your seat. They're going to qualify, and you're going to have to defend everything that you've ever said in an opinion. And so it's a process that really, I don't think, works very well, just to have popular election of judges, especially on a statewide basis, because you know, it's just a chance for all kinds of mischief when you're having to raise money and you're having to promise people things that you really can't promise in order to get elected. And your opponent is out there promising to do the opposite. That's really a process that I don't think works very well.
It is amazing to me, in other states, and a lot of our southern states have contested statewide judicial elections, and their appellate judges raise millions of dollars, which is hard for me to believe. And obviously that money comes from special interest groups, I would assume.
Yeah, there are always people who have money or can raise money, who are interested in one particular thing, and they can go out and raise a lot of money and use it in a campaign against a sitting judge, and that's just not a very healthy situation, I don't think.
If the 12 members of the Court of Appeals all had to take off and raise money and campaign and be away from the bench, I know in judicial races in Ohio, for example, and in Texas and Alabama, they have staggered terms. But in Tennessee, all 12 of you and all 5 members of the Supreme Court would be running at the same time, so you'd be away from the bench. But in Ohio and Texas, you still will have like 2 members out of the Ohio 7-member court that basically take a year off to raise money and to campaign. What would that do to your workload?
Well, I guess the work of the court would just grind to a halt until the general election. And I don't know, when you'd have to, seems to me, in order to raise enough money to run a statewide campaign, you'd have to be doing that constantly. And the active campaigning would start very early in the year. And if you're having to speak to the Rotary Club in Johnson City, that takes off a lot of judicial time to go from there to Memphis to campaign. And it would just be an extreme hardship on the Court of Appeals or the Supreme Court either in order to do that.
You, when you were on the Chancery bench, always in the bar polls, led the bar polls, and then when you were on the Court of Appeals, as I recall, your judicial evaluations, which were made public, were always the highest. How do you account for that?
Well, I don't really know. The judicial evaluation, they get input from the general public, but they also get a lot of input from lawyers that have practiced before you, from your colleagues on the bench, from other judges across the state. So I really don't know. I always tried to get along, and I always tried to keep up with my work, and so I think that had a lot to do with it.
Well, you were always current, and I think one of the things I always heard from the Chancery bench and from the Court of Appeals was that you were such a good listener, and I think clients and lawyers appreciate judges who will be listening to their case. But you should be very proud of all of your high marks. Well, now this is my next to the last question. Is there anything else you wish I had asked and you would like to tell us?
I can't think of anything, Judge. It's been a marvelous career. You and I talked not long ago and reminisced a little about our time in Chancery Court, which is now 40 years ago nearly, and it all seems like yesterday. We agreed on that. And I've enjoyed every year. I enjoyed what I did. I enjoyed my time as a trial judge. I enjoyed my time on the Court of Appeals and all the people I got to see and associate with, and all the things I learned while I was serving as a judge. A lot of that time while I was a judge, I was also teaching a class at the night law school, and I always told my students that I hope they learned something from me, but I learned more than they did probably, just trying to get ready to face that class every week. I enjoyed that, and it's just been a marvelous experience.
You've always been a great mentor, and you were a mentor to your fellow judges and younger judges, but I understand you do some mentoring now in the practice of law.
Well, I try to, and for a while the Nashville Bar Association had a mentoring program that was really active, and I thought it worked very well. And I'm always available if anybody has a question they would like to ask. I may not be able to answer it, but I'll try. And so I think that's one of the things that that may be lacking now that the bar is so much bigger than it used to be. But I think every young lawyer needs somebody that's been around a while that they can just ask a question to. And there are a lot of people in Nashville that serve in that role. And so you can go and ask them, and it's a very, very big help to all of them.
One thing about you, you've always led by example, and you've set a wonderful example. My final question, how would you like to be remembered as a judge?
Well, I'd like to be remembered fondly, of course. I just guess that every judge's hope is that people remember that you did listen, and that you were fair, and that you took care of your court, and you ran it with as much dignity as it's possible to do. Basically, I guess that's it.
Well, I want to thank you, Ben, for participating in this legal history project of the Nashville Bar Association, and thank you for your many, many years of public service to this state. And I also want to thank our videographer, Jim Davis.